Good afternoon, everyone, and welcome to our today's session on immigration law. And we'll be discussing some important changes that are coming into the UK immigration laws. And we have got with us our daily favorite, Mr. Khandokar Omar Farooq, who is a solicitor and director as well as a long-standing immigration practitioner in the UK. Welcome, Mr. Farooq, in today's discussion.
Thank you so much, Jaideep.
So if I just go straight into the fact that what do you think that the most important immigration changes in the UK right now?
Well, as you know, I think at the moment, millions, probably a million and so, people thinking about the ILR. Okay.
Hmm.
As you know, the autumn changes came into effect in March, the 5th, after March, like the 5th. But the $1 million, million pound questions, I think majority of concerned skilled worker or who are about to complete annual long residence, they are concerned about whether these new changes, um, the Home Secretary said is going to come into effect in autumn,
Hmm.
But they have already changed this goalpost. They said it would come into effect in spring, which is gone already. So now they are
Hmm.
saying in autumn. So basically, two questions remain unanswered. Whether this 5-year rule, they change it to 10 year or 15 year, I think
Hmm.
if it is for future applicants, I think that's not a problem. But it bothers a lot of people that whether it will be a retrospective effect or not. And the Home Secretary time and again said, yes, it will be. And the vested group, they're ready to fight it. As you know, some quite reputable barristers firm have already got the instructions. So once they implement this ILR 5-year to 10-year or 15 years rule, the government can expect a pre-action protocol later. I think by this time that's um, barristers they have already prepared it, drafted it, just waiting. So two things remains outstanding. And other one is, 10-year long residence. So if you are lawfully and continuously in the UK on any visa, like a student visa, work visa, family visa,
Hmm.
and then add the current rule, according to the current rule, you can apply for 10-year long residence, continuous long residence, ILR. Uh, the dilemma is the government said that low skilled worker, well, I don't want to use this term. They said like who are low skill like care worker and construction worker, their ILR will be 15 years. ILR rule. After 15 years, they
Yes.
can they can settle. Now, if you keep this 10 years long residence, then it will be contradictory, right? So they so far they have, I mean, just in the market, like people are saying, maybe this continuous long residence will be there, but it will be like you have to be on work visa or family visa, or maybe they will remove it completely, but it could be like the changes, you could have used it in the past, like a student visa, work visa, family visa, asylum, whatever. Um, but in this case, it could be, say, for example, that if you are on a skilled worker visa in this country on a 10-year route, then you can apply on 10-year long residence, something like that. I don't know. We'll see. We'll
Right.
see.
Yeah. So yes, it has. I mean, lots of it will have lots of impact, intentional or unintentional, whatever it is. You have mentioned one thing that retrospective effect. We have heard about prospective and retrospective effect. So if you can just explain those things for the spectators, please.
Um, Normally, when we enact a law, um, the implementation date normally, especially immigration rules. there is
Mm-hmm.
a convention, like they give like 3 weeks prior for implementation. So, for example, if the rule is passed, if the rule is enacted today or by secondary legislation, there's a famous, like, under Immigration Act 71, for the secondary immigration rules to change any rules, the Home Secretary doesn't have to make it as a law, like enact a new act. They can just
Mm-hmm.
simply put it in the parliament and aye or no, this, and
Mm-hmm.
that's it. They become immigration rules, which has the force of the law. So um, this one, I think, impact to a lot of people. Uh, they, estimated 1.6 to 2 million people. So it's obviously concerning. And respective effect, like when you enact a law, it should start implementing from a certain date in the future, not from the back. Because there is something called legitimate expectation, which is also established by upper court's decision.
Mm-hmm.
Um, and the government said, no, we will not, um, uh, we will implement from the past, to put it simply for a layman's understanding. Say, for example, you enact a law, you enact a rules, or you pass a rules, and you say it will be effective from 5 years before, which is, I mean, um, normally is unreasonable. But you have probably heard that British Parliament can everything except two things: to make a man a woman and to make a woman a man. Apart from this, they
Yeah.
can change everything. So
Yeah.
what this government is doing, the next government can change everything. That's not a problem. So we'll see, because even after Parliament, there is um, legal system, and we have to wait and see how it pans out at the end.
Okay. So yes, I was looking at a paper the other day, and it also says that in the past it happened that the Home Office and the UK Parliament did give the immigration law retrospective effect, even if it is not, expected or accepted in the legal luminaries. I mean, the thing is, when we talk about rule of laws, it always says that law should be prospective, not retrospective. And yes, of course, we'll have to see and we'll have to wait for the future. I mean, in the future to see what changes are
I
coming
mean,
up.
the important thing here, like, say, for example, the government will say to the court, look, there will be a threat to our economic security. Like,
Hmm.
well, um, according to their estimate, 1.6 or 600,000 people who are low skilled workers, once they get ILR, that could be a big burden on the public fund.
Hmm.
You just can't simply brush it off, from the past experience. And when it comes to national security, economic security also includes national security, you know that. And
Yeah.
the Lord Denning's famous, quote or judgment, whatever you say, like, when there is, I mean, he was a very liberal judge, but when it comes to national security, he said, forget about the human rights and Article 8 or blah, blah, blah. Because if we don't exist as a nation, then how can you expect, all this human rights and blah, blah, blah? So we have to see, wait and see.
Yes. Yes, definitely. We have to wait. There is nothing to. We can just expect to see it in the perspective. Well, let's wait for that.
Yeah, let's hope for the
Okay.
best, ready for the worst.
Yeah.
Hmm, hmm.
Okay, yeah, that's what our spectators should do as well. So, I have seen, a recent change in the skilled worker sector regarding the salary requirement. It's quite a rigid requirement. Can you just touch that point as well?
Well, from 8th of April 2026, they changed the guidance. So, say for example, in the past, you hired a worker and your
Hmm.
business is doing bad. So, this month maybe you don't have money in your account, in your company account. So, not enough money. You paid him less and saying that I'll pay you the balance next month. So it was
Hmm.
allowed before. So as long as it was gross per annum as per your cost, that would have been fine. But this from 8th of January, what they say, like it has to be every period, which means normally if you wish to get per month PCM, per month salary. So
Mm-hmm.
I give an example. Your salary is 30,000 gross, and you have to be paid every month 2,500 gross. So it cannot be like this month I pay you 2,000, next month 3,000, and after that month 5,000, and next month 500. No, it will be an issue for ILR, and also this will be an issue for the employer if this HMRC and Home Office is they're connected. They can check on their system that whether this person paid enough taxes, and through this they can catch the employers, and the employers lose their license and other penalty action, and obviously the skilled worker status will be jeopardized, precarious situation. So,
Yes.
but there might be one exception, which obviously won't be used generally. Say, for example, you are sick and you are on a maternity leave. In that case, the employer can pay in the variance up to 3 months with a reason. It cannot
Mm-hmm.
be used as a general exception. So this is just a limited exception.
All right. Okay. So yeah, I mean the employer who are uh, sponsoring the skilled worker as well as the skilled worker both need to be very cautious about it. So I mean we have seen, I mean the home office are we are seeing that lots of sponsor license are being refused in the recent days. I mean record level revocations. So what are the practical advice you would give to the sponsor holders? I mean the employers as well as the employees.
The employer should keep their HR file, every employee is up to date. The employer should pay the salary of the employee according to their costs and on a periodic basis, like
Mm-hmm.
not like here and there, and because it will affect both the employer and employee. Employee when they go for ILR, the home office will check every detail, and they can do it within minutes because it's connected with their system, the HMRC system, and also the employer might find it very frustrating for them. Uh, they might all of a sudden they can see the enforcement people turn up their office or factory, and
Mm-hmm.
they can lose their license. And it's because this employers compliance duties, there is no deviation. So if you breach
Yeah.
just one duty, the home office doesn't have any discretion but to revoke or suspend your license, because this is quite rigid, as you said. So the
Yeah.
employer should, and say for example, on your the other day, you remember, like we had a consultation. I had an immigration consultation over Google Meet with a client, and he said the employer is giving me hard time, blah blah. And I said, okay, show me your cause. And I read back to him the cause description. I said, out of this job work, what you are doing? He said, I'm doing everything. So what is the problem then? No, it is very hard. I said, look, the employer issued a cause in your name and your job description in the cause letter, and you are doing as per the cause. If you are doing something which are not cause, which is not mentioned in the cause, then it's a
Mm-hmm.
violation. So, for example, you have mentioned 8 duties in the cause, and you are doing only 6, or you are doing 1 or 2, which is not mentioned in the cause. The home office find out, they will definitely revoke the license and you will lose your status. So there is
Mm-hmm.
no ifs or but.
All right. Thank you so much for your fine advice. And yes, Avista can help you in this way as well. So if you need any help or any guidance, yeah, please feel free to contact Avista Solicitors at the given number or email, and we'll be more than happy to help you. So thank you, Mr. Farooq, for today's session and for attending and giving your valuable advice. And if you have any last word for the
Lastly, I would like to
viewers.
say to my viewers, listeners, and well wishers that if your ILR is ending coming soon, do apply as soon as possible.
Hmm.
On the other hand, if your ILR is not coming soon, then make sure you get paid as per the cause and periodically. And you emphasize, you push the employer within your limit that they need to keep your file updated, HR file updated. Lots of employers, they don't bother, but it's for your own interest. You should encourage them for to keep your HR file updated. Okay, so thank you so much, everyone, for watching this evening. And I wish you all the very best. And thank you, Joydev, for your good presentation and have a lovely weekend.
Thank you so much, and same to you, and very best wishes for our viewers as well. Have a nice evening, everyone.
Thank you.
Bye.
Okay.